Have you ever wondered about the true flexibility of employment relationships, particularly when it comes to ending them? It is a common misconception that all jobs can be terminated instantly without consequence, but the reality is more nuanced than that. At-will employment generally means that an employer can terminate an employee for any reason or no reason, with or without notice, and an employee can also leave a job for any reason or no reason. However, state-specific rules significantly modify this default principle, adding crucial protections and requirements that vary widely across the United States. The core mechanism behind these variations lies in state common law and statutes that create exceptions to the at-will doctrine. While most states adopt at-will employment as the default, nearly all recognize at least one of three major exceptions. The public policy exception prevents termination when it violates a clear public interest, such as firing an employee for refusing to commit a crime, whistleblowing, or filing a workers' compensation claim. The implied contract exception arises when an employer's actions, statements, or written policies, like those found in an employee handbook, create an expectation of continued employment or specific termination procedures. Finally, the covenant of good faith and fair dealing, recognized in a minority of states, implies that neither party will act in bad faith to deny the other the benefits of the employment contract. For businesses, understanding your state's specific exceptions means carefully reviewing employee handbooks, consistent application of policies, and training managers on compliant termination practices. It is not just about avoiding lawsuits, but about fostering a fair and predictable workplace. For employees, knowing your state's rules empowers you to understand your rights and protections. Documenting any promises or representations made about job security or referring to your company's official policies can be very important. The legal landscape of at-will employment is often perceived as a simple concept, yet its practical application demands a detailed understanding of state-specific interpretations. For instance, some states recognize all three major exceptions, while others only acknowledge one or two, and the scope of each exception can differ dramatically. This patchwork of regulations means that a termination that is perfectly legal in one state could be grounds for a wrongful termination lawsuit in another. Ultimately, navigating the complexities of at-will employment rules requires both employers and employees to be informed about the specific legal framework governing their state. Being aware of these state-level nuances protects all parties, ensures compliance, and promotes a clear understanding of rights and responsibilities within the workplace.